balancing their interests of wanting to throw the book at defendants and ours of obviously pursuing justice. You know,
Yes,
even
yes.
the person that there.
Was that even the in-person have what they want?
Oh, drop, yeah,
And perhaps you got some strong evidence when it's clear. It's just,
yeah,
you guys get placed on a wrong.
Who is this?
yeah. It's a challenge.
Okay.
All right.
All rise. The three-part law out session. The Honorable Robert J. Horn presiding. Be seated.
Good morning, councils.
Morning, Your Honors.
Just give us a second. Will the clerk please call the case?
This is Supreme Court case number CRA22-011, People of Guam Plaintiff Appellee v. Chris Jr. Anderson Tedtaotao, Defendant Appellant. Appearing for the Plaintiff Appellee is Attorney Grant Olin. Appearing for Defendant Appellant is Attorney Christian Spatansky. Panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Spatansky reserves 15 minutes.
Good morning, councils. Thank you both for coming today. As you know, Justice Merriman took ill this morning and is not present on the bench. She indicated that she would either watch all arguments on the live YouTube channel or would come back and listen to the tapes. And I believe both councils were apprised of that. I just would like for the record you to state your non-objection to us proceeding on that basis today. And we'll start with you,
Your Honor, we do not object.
Mr. Olin.
People do not oppose, Your Honor, and hope that Justice Merriman is there's nothing serious.
And I think it'll be fine. And we thank you for your indulgence and cooperation with the court today. You may proceed.
Thank you, Your Honor. Mr. Chief Justice, and may it please the court, to provide a roadmap of sorts, I will present an overview of the facts that led to this hearing before addressing three arguments. The first two concern a plain reading of Mr. Tedtaotao's plea agreement, while the final argument addresses what we believe should be the applicable standard of review. This case concerns a plea agreement signed by the defendant, Mr. Chris Tedtaotao. Mr. Tedtaotao signed that plea agreement in August 2018, and the court below accepted that agreement the same month. That plea agreement, among other things, required Mr. Tedtaotao's cooperation in two criminal cases, CF 690-17, CF 691-17, and one criminal incident, the events that occurred in the attack on Justin Meno in March 2017. Mr. Tedtaotao cooperated, that is undisputed, both sides agree. However, in November 2021, the people submitted their first sentencing memorandum where they argued Mr. Tedtaotao violated the terms of his plea agreement, thus becoming subject to a provision in that agreement. And that provision is better referred to as paragraph 9E. That paragraph states, the defendant will remain released until after his cooperation is completed. If the defendant commits a new offense, tests positive for any drug or alcohol, or does not appear to the probation office or to court as requested, the defendant will serve 5 years in incarceration if he cooperates later, or 10 years in incarceration if he does not cooperate. The people's assertion for Mr. Tedtaotao's violation of the paragraph was based on their belief that Mr. Tedtaotao committed a crime in September 2018 before a co-defendant pled guilty in CF 690-17. That co-defendant pled guilty in February 2019. This fact, however, was incorrect, and I don't want to suggest any improper motive on the part of the people. In truth, new information showed that Mr. Tedtaotao actually had committed that crime in April 2019, which was 2 months after the co-defendant pled guilty. Nevertheless, Your Honors, the people submitted a second sentencing memorandum where they continued to argue that Mr. Tedtaotao violated the paragraph since he should have been expected to cooperate in a dismissed case, CF 330-17, which concerned the Justin Meno incident.
Let's go back to the plea agreement that you cited, which was section 9E of the agreement. And the first sentence of the agreement provides that the defendant is going to remain released until his cooperation was completed, right? And so when he committed the other offense, he obviously was on release, right?
Correct, Your Honor.
So, and if he was on release, doesn't that make clear that his cooperation wasn't completed yet?
I would disagree, Your Honor. I think the way to term cooperation would be by looking at the context of the entire plea agreement. We actually have the definition of what is deemed cooperation. That's provided in paragraph 8B. There, it says the defendant agrees to testify truthfully at any court proceeding. This can include a grand jury, a trial, any other hearing to which he is called to testify specifically concerning his case or those involving his co-actors.
Right, and the first two cases, I don't think are relevant because both of those were concluded before the offense was committed.
Yes, Your Honor.
And so the only one that remains is the events that occurred in the attack on Justin Meno in March 2017. And I recognize that Mr. Meno's case was dismissed without prejudice previously back in February of 2018. But the fact that he still was on release when he committed the offense, you know, if you read paragraph 9E, that says that he will remain on release until his cooperation was completed. And so if his cooperation was completed, then doesn't it make sense that he would then be sentenced and go forward with serving the sentence that was provided for in the plea agreement?
I think I would agree with that, Your Honor. However, when we look at when his actual sentencing hearing was, when the parties were turning in their sentencing memorandums, that didn't occur until 2021, which was long after the prosecution had argued he should still be on the hook.
You mean 2022?
Thank you, Your Honor. Yes,
July 18th.
2022. Yes. Your Honor, if I could just address the issue today, it's simply whether or not the trial court erred in applying paragraph 9E during Mr. Tedtaotao's sentencing. Obviously, our position is yes, we do believe so, and we'd ask that this court remand with instructions consistent with today's hearing. Our first argument, ironically, begins nearly where our reply brief ends. The word later matters. This argument proceeds keeping in mind what the court recently reiterated in People v. Pilot. Specifically, when analyzing a plea agreement, this court must first consider the plain language of the agreement. Having already stated what's in paragraph 9E, I will not repeat it. What is seemingly implied in the paragraph is that it may be invoked when one, and I look at this through elements, one, the defendant either commits a new crime, tests positive for drugs, or fails to show up to court or probation, and two, the people still have a matter for the defendant to cooperate in. This belief obviously focuses on the word later. The paragraph assumes a situation in which the defendant commits a violation before cooperating with the government, And this is exactly why the word later is written into the language. This is probably also why there's a lesser and greater form of punishment, because the people are still concerned with whether or not Mr. Tedtaotao is going to cooperate. Here, admittedly so, the defendant never did cooperate after committing the crime in April 2019, nor did he have the chance to do so after committing a new crime. The people, we believe, would have this court find that the paragraph still applies since the statute of limitations for the least serious charge in a dismissed case had not yet expired. I would also add a further point that when we look at the Justin Meno case, and this is probably presenting a hypothetical because from our understanding, that case was dismissed after the medical examiner produced new evidence showing that Mr. Meno likely died of a malignant tumor. If we assume hypothetically that Mr. Meno was actually killed by the hands of inmates at DOC, the likelihood that the prosecution wouldn't seek Mr. Tedtaotao's cooperation in a murder trial seems very unlikely. They further argue that since Mr. Tedtaotao is subject to the paragraph, he should nevertheless receive 5 years incarceration since he had cooperated before violating the terms of his plea agreement. But again, that's not what the paragraph states. It simply states that the defendant must commit a new offense and then either cooperate or not cooperate. And I want to stop here and say I am not suggesting that my client should actually be subject to the increased sentence of 10 years incarceration. This is based on 2 reasons. First, again, Mr. Tedtaotao simply never had the opportunity to cooperate after having committed a new offense. A decision that I will suggest is actually because the people never did re-indict the mental incident. Second, as per the terms of paragraph 9E, a defendant can only fail to cooperate under certain circumstances. Mr. Tedtaotao never refused to testify. He never testified differently than what he previously had said, and he had never disappeared to avoid testifying. Your Honors, this paragraph.
Doesn't the potential exist that the commission of the new offense while he was out on release and before, at least as the government asserts, his cooperation was not completed and the Justin Meno case was still outstanding and they potentially could have re-indicted it within the period that they were talking about, that his commission of another offense would potentially undermine his credibility as a witness and his effectiveness as a witness in any subsequent proceeding?
Your Honor, I find ourselves in a very precarious situation because I actually do agree with what you're saying. We did concede in our reply brief that one way that this paragraph could have been correctly invoked is if the people had actually re-indicted that matter. Because if that was the case, then we could have expected Mr. Tedtaotao to be called to a sentencing hearing for one of the co-defendants in CF330-17, perhaps if there was a grand jury proceeding. Nevertheless, Your Honor, in your question, one of the key words you said is potential. And I don't believe that we should be holding Mr. Tedtaotao to this paragraph on a potential case that could have been brought up, simply because it never actually was. If I could actually refer to the people's first sentencing memorandum, I do believe that they essentially walk back on their own words. They described the paragraph in question, and underneath that paragraph, they state, and I quote, "This provision unambiguously states that if the defendant commits a new offense before the need for his cooperation against his co-defendant terminates, parentheses, either through a plea agreement, conviction at trial, or dismissal of the case, then he shall serve 5 years in jail." That's exactly what we have here when we look at CF330-17. It was dismissed. Yes, it was dismissed without prejudice. However, they don't even make the distinction between with or without prejudice in their first sentencing memorandum. If I could move on to my second point, if there are no questions, Your Honor.
Let me just walk me through this again. Because the key question here is when Mr. Tedtaotao fulfilled his end of the bargain. And your argument is that's on February 27, 2019, when the theft at the Umatek occurred. Is that correct?
Yes, Your Honor.
And because the armed robbery in East Agana occurred after that date, of course, the other incident, February 27th, that's what you felt triggers the end of his cooperation, or when it was complete. And the people argue that the date is in 2022, when the attack on Justin Meno had not concluded as of that date. And so I'm just trying to get the dates here. I understand the benefit of the bargain interpretation, that what you are representing. And so those are the dates to you that trigger the interpretation of the agreement as to when Mr. Tedtaotao fulfilled his end of the bargain. Am I getting those dates correct?
Your Honor, you did say that the prosecution said that the cooperation would have terminated in 2022.
Yeah, June 27, 2022. The people argue that that's defendant's cooperation in prosecuting the attack on Justin Meno had not concluded when the new offenses were committed.
It's my understanding that the date that they've been using is actually March of 2020. The date that the statute of limitations for the
Yeah,
least
but then
severe.
I think they walked away from that. This is my understanding. They abandoned that. I may have misunderstood. And I'm sure counsel for the government will clarify. But that's the date I understood as to what they're arguing now. It's really not all that critical because the offenses in question, occurred in 2019. So that, well, I guess it would. So is my chronology in any way different from what you're arguing?
I do believe so, Your Honor. Our understanding is that the termination of cooperation, at least in the eyes of the people, would have been March 2020. 2020, excuse me, which is 3 years after 2017, which is when the Meno incident occurred. And the 3 years is for the statute of limitations expiration for the lowest charge.
But originally, the government's position was it was in February until they realized that the offense occurred after that date that they had argued for in the trial court.
Correct, Your Honor. And let me just concede one point. I actually do believe, had the fact been correct that Mr. Tedtaotao committed a new crime before February 2019, that would have been a proper application of paragraph 9E.
Yeah.
The fact was wrong.
And that's the date that the trial court found the defendant cooperations ended, when the last of the co-defendants pled guilty, and that's Mr. Kosek, right?
Originally, yes, Your Honor.
Yeah.
I do believe defense counsel's initial argument was double jeopardy. The trial court reviewed it. They denied it. Yes.
And the argument is that the trial court was wrong as to the date of both the Agatnya and the Nico robberies. They use a September 27, 2018 date.
Yes, correct. The new date was actually April 2019, 2 months after Kosei had pled guilty.
All right. Okay. I think I pretty much confirm that information from what you are stating.
Thank you, Your Honor. If I may move on to the second part of my argument, but we're still following the court's proceedings when we're analyzing plea agreements. If this court is inclined to agree with our first argument, the next step would be to look at what was reasonably understood by the defendant when the plea was entered. In most cases, I think we'd be forced to speculate what went through the defendant, Mr. Tedtaotao's mind at the time the plea agreement was entered. Here, I do not believe we have that problem, at least in regards to Mr. Tedtaotao's thoughts on the dismissal of the Meno incident. If we look at the record, ER 50, lines 8 through 12, Mr. Tedtaotao stated at his sentencing hearing that, I quote, "I was told to cooperate when they came forward. When we heard it was dismissed, we kind of all jumped and said, hooray. There was a bunch of us leaning on that. So, I mean, I stayed loyal until the end." I do believe the court mirrored this sentiment. In the record at ER 47, lines 10 through 16, the court states that, "At first, I would have agreed with you, being the people. But when you're saying that now that there was this case that was charged out and dismissed, ultimately, one would think that his obligation to complete the terms of his plea agreement should not include the recent arrest, because everything that he would have cooperated in was already done." Your Honors, it seems pretty clear what Mr. Tedtaotao understood when he entered into the plea agreement. Mr. Tedtaotao appears to have believed that a dismissal signaled the end of cooperation for the Meno incident. And like I stated earlier, one might assume the people believe this as well when we look at their first sentencing memorandum. Your Honors, Mr. Tedtaotao, like the people, believed the dismissal of CF 330-17 eliminated any need to further cooperate in the Meno incident. Your Honors, if there are no further questions,
But one fact that may have been overlooked, there was, according to the plea agreement, the only scenario where Mr. Tedtaotao where he was not in prison would be if he was cooperating. And so, I mean, the fact that he was still released, then that suggests that he had not yet fulfilled his end of the bargain.
To answer your question, Your Honor, I guess I would ask another question is, after March 2020, why wasn't any sentencing proceeding brought forward? He actually had remained released for a while afterwards. I don't want to suggest any improper behavior by the people, but it simply, to me at least, suggests that perhaps the courts were too busy to initially bring Mr. Tedtaotao back into the court to hear his case.
Or the government just hadn't come around to make a decision on Justin Meno, whether or not to re-indict him.
I would agree with that, Your Honor. However, at the end of the day, Mr. Tedtaotao would have never had the opportunity to cooperate in it because as of today, they still haven't re-indicted that matter.
All right.
If I might move on to my final argument, Your Honors. As a final note, I'd like to discuss the standard of review that we believe should be applicable in this case. Our position is that this appeal should be reviewed de novo. The people argue that the applicable standard should be plain error since defense counsel did not specifically object at the trial court level. I'd like to briefly refer to Piolet. In Piolet, during sentencing proceedings, upon Mr. Piolet's sentencing, the trial court allowed defense counsel to state the reasons Piolet shouldn't have received the decided sentence. Yet defense counsel did not contend that the court was precluded from considering Piolet's level of cooperation as an aggravating factor at sentencing. Here, that is not the case. Mr. Tedtaotao's attorney immediately raised concerns with paragraph 9E, which can be seen in defense counsel's first sentencing memorandum. I said earlier that the first argument was a double jeopardy argument. The judge ultimately denied defense's motion, but Mr. Tedtaotao's counsel quickly shifted the defense to reflect the people's error in mistakenly saying that a crime was committed before CF 690-17 had concluded. At the sentencing hearing, the court below acknowledged at ER 45 lines 18 through 22 that the hearing had been continued a couple of times because an issue continually pops up when we're discussing paragraph 9E. Specifically, they said at first it was whether or not Mr. Tedtaotao had committed an offense before or after the expiration of the plea agreement. And furthermore, Your Honors, we have already discussed the trial court's opinion regarding the defendant's possible beliefs regarding the dismissed case. My point in all of this, Your Honors, is to show that defense counsel and at sometimes the trial court itself focus the arguments on the validity of paragraph 9E in several different stages. This is not a case where defense counsel remained silent when the trial court decided to discuss the applicability of paragraph 9E to Mr. Tedtaotao's circumstances. In conclusion, Your Honor, the trial court erred in applying paragraph 9E. I think this phrase is often overused, and I hope I don't look back on this and cringe, but the people cannot have their cake and eat it too. Mr. Tedtaotao respectfully requests that this court reverse the trial court's decision and modify his sentence.
Thank you.
Thank you, Your Honors.
It's a perfect transition to the government because one of the questions I had was this issue of preservation of this argument on the and whether it was preserved in the sentencing memorandum, Mr. Owen.
CJ, I just wanted, did
Yes.
they state for the record that they have no objection?
Yeah,
Yeah,
at the
they did.
beginning, they
Okay.
did. We got their consent to
All right.
proceeding. Good morning, Mr. Olin.
Good morning, Your Honor. May I begin?
Yes.
Oh, thank you. Chief Justice, may it please the court. The trial court correctly sentenced defendant Chris Tedtaotao to the minimum sentence of 5 years imprisonment under paragraph 9E of his global plea agreement, and therefore did not err.
Let's talk about the standard of review. You heard counsel, talk about the fact this issue was raised in the sentencing memorandum. The government argues they raised it for the first time on appeal, and therefore it's not a de novo review.
Yes, Your Honor.
Why doesn't the issue being raised in the sentencing memorandum sufficient for us to examine it then de novo because it was preserved by counsel?
Well, there was nothing raised about the specific issue of whether the trial court erred at the sentencing hearing. I'm referencing the defendant never raised the issue of whether the trial court erred by determining that he committed a new offense before his cooperation expired on March 29, 2020, when the statute of limitations on the Justin Mino matter ran, and was subject, therefore, to the 5-year sentence under paragraph 9E of his global plea agreement. The time to have raised an objection would have been at the time that the trial court actually specifically considered that specific matter, and defense counsel never ever raised an objection or addressed that specific matter at that hearing, Your Honor. So the people believe that on that basis, the standard of review on appeal of this specific issue is plain error. Now, the defendant entered into a global plea agreement for three very serious offenses in which he was facing up to 15 years imprisonment. As part of the agreement between him and the government, the parties agreed that the defendant would only serve 3 years in jail in exchange for his cooperation against his co-actors and, as discussed in another matter involving the attempted murder of Justin Meno.
You agree that the first two matters are not at issue here, right? I mean, the government's position initially was that he had not completed his cooperation in the, I believe it was the Hills Market robbery involving his co-defendant, Kose.
The people believe that neither his cooperation against his co-defendants or the Justin Meno matter are relevant or at issue here, Your Honor, because under the paragraph 9E, the reading, plain language of paragraph 9E, the defendant was not to commit any new offenses while he was on release. And if he did, his sentence would then be enhanced to a sentence of 5 years imprisonment if he had cooperated with the government, or 10 years imprisonment if he hadn't cooperated with the government. There's no dispute here, Your Honors, that the defendant committed new offenses. Defense counsel has conceded that.
But you kind of, that reads that in isolation somewhat, and doesn't take into consideration the first sentence of that same paragraph. And it seems that looking at it in that regard and in isolation might open the door to potential abuses in future plea agreements, where, for example, there could be a threat of additional time for commission of an offense could be held over a defendant's head longer than the probation or the suspended sentence that might otherwise be provided him.
Well, for all practical purposes, Your Honor, the part of every plea agreement is an understanding between the parties that defendants will comply with certain probation terms and conditions. And if they commit a violation, they could be then, their probation could be revoked and they could be subject to an entire sentence. This is just, it's a different form of that agreement or that specific kind of provision, in the sense that he was allowed to go on release while he was supposed to cooperate with the government. And from the people's understanding or interpretation, based on the plain language of that provision 9E, it specifically indicates that he's not to commit any new offenses while he's on release. Between when he's on release and when he is actually sentenced, he did commit new offenses. Notably, it seems incredulous from the people's perspective that the parties would have believed that it would have been all right for the defendant to have committed new offenses during his release simply by having completed his cooperation in the matters agreed to. That seems to be defendant's position, that he reasonably understood the agreement to mean, that provision to mean, that once his cooperation with the government was completed, he could commit new offenses while on release. That's absurd. And so he was on release and he was charged for committing new offenses in 4 new cases while on release. Moreover, he was convicted of new offenses while on release via a global plea agreement for CF 11819 and CF 23719.
So you're suggesting that not until the government decides that it wants to move for a hearing on sentencing, and if Justin Mendel's case was still pending, there's no statute of limitations for that. So it's just whenever the government decides in its discretion, it wants to move for sentencing, so long as it's within that time period, that was what the agreement contemplated, that the parties had intended.
From the people's perspective, Your Honor, that provision meant so long as he was on release pending sentencing, that he was not to commit any new offenses, violations. He did. And of course, it's the trial.
If the government decides they wouldn't move and, still within the statute of limitations for another 8 years, that would be okay under this plea agreement?
Well,
10 years, 15 years, 20 years?
yes, Your Honor, absolutely.
That would seem absurd.
Well, practically speaking, Your Honor, no one would be out on release for that extent or long a period of time. Of course, it's within the court's discretion as well to call a sentencing hearing for that specific matter. The fact of the matter is that he committed new offenses while he was on release and at a sentencing hearing, which was
his
within.
cooperation
Mhm.
done when he committed those full offenses? I mean, I think that's the question that the trial court was addressing. And that seems to be the question that, we have to address is, when was his cooperation complete? They argue the case was dismissed against Mennel. The other two persons had pled. Therefore, his cooperation was completed and he had fulfilled the terms of his agreement as far as the cooperation was concerned.
But then that it was okay at that point in time for him to go out and commit new offenses.
Of course, it's never okay, but what we're struggling with here, what was the party's understanding at the time this plea agreement? And so counsel for Mr. Tedtaotao made it very clear that at the time that he entered into the plea, the offenses that were cited for the Isagana and the pneumatic robberies had already been completed or shortly thereafter, after Mr. Kosei was sentenced. The only thing pending was the Justin Mennel case. And their understanding is that, since it was dismissed and for the reasons that counsel articulated, that it was unlikely that that was going to be recharged. And as counsel said, to this day, they haven't charged it. There seems to be some truth in what was argued there. But you seem to say, well, we can decide whenever we get around to it, what to do in that case. And if he's released during that period of time, he's still subject to this plea agreement. I'm struggling with that interpretation.
Well, first, it should be noted that both the government and the court agreed to an enhanced sentence to the minimum sentence of the 5 years on the basis that the defendant had cooperated, Your Honors.
And I don't think there's any issue as to that, is there?
Right. And also the fact of the matter was that the statute of limitations hadn't yet run for the Justin Mennel matter before he committed and was convicted of his.
And that was your change theory. The original theory was
That was the original theory. Oh, right.
February, and then they realized that the offense occurred after his co-defendant in the Hills robbery pled guilty. And so the government shifted wheels and went to the gears and went to the statute of limitations on the Justin Mennel offense.
So I suppose there's two different ways to look at this, Your Honors. We could look at it from the perspective that where the trial court eventually landed, which was the fact that the Justin matter could have been charged up to March of 2020, and the defendant had committed new offenses while on release and was convicted of new offenses while on release before the March 2020 statute of limitations ran. Or we could see it from perspective that people are arguing now, which is that it didn't matter whether or not he had cooperated. The issue was whether or not he committed new offenses while on release. And the fact that he did then subjected him to an enhanced sentence, either 5 years if he had cooperated, which he received, or the 10 years if he hadn't cooperated.
What about I guess that doesn't address the second part of your argument. I mean, you have two alternatives. The one that it's an enhanced sentence because of the commission of the new offenses, even with the cooperation. But the defense argues that Justin Meno's matter, when it was dismissed initially, and in fact, cited to the record where he felt that his cooperation then was done and was no longer needed when that case was done. And if you look at paragraph 9 again, and it talks about in consideration of his pleas of guilty and a cooperation, he's going to be sentenced to 5 years, all but 3 suspended with credit for time served. There's no mention in that provision, obviously, about the convictions or commission of additional offenses that's occurring in a later provision of the same paragraph. But they argue at that time the Meno matter was dismissed. The 2 other co-defendants in the 2 other instances in which the cooperation was specifically identified had pled. And so therefore, in accordance with 9A, he pled, he cooperated, and therefore gets the 3 years.
So I actually wanted to address that specific issue, your matter. Notably, CF 330-17, the Justin Meno case, was dismissed without prejudice on February 7th, 2018. That was before the defendant entered into the global plea agreement on August 7th, 2018. So essentially what the defendant is saying is that at that point in time, because it had already been dismissed, he didn't think he needed to cooperate any longer. Well, the plea agreement hadn't even been entered in this case yet. And so the defendant should have been aware at that point in time when the plea agreement was entered that CF 330-17 could have been recharged at a later time. And it is true that it hasn't to date, has not been recharged for whatever reason, which really isn't material to these proceedings. What is material, if one of the theories is that provision of 9E only applied if the defendant failed to cooperate, committed new offenses before he cooperated, then the statute of limitations, according to for the lowest charge or highest charge offense, lowest charge offense would have been the 3 years, and then run in March of 2020. And so the new offense that the defendant committed and was convicted of did occur before that date. But again, the people's perspective is that so long he was on release and committed new offenses, he therefore was subject to the enhanced sentence, and the trial court didn't err. In the end, Your Honors, under either reading of those 2 interpretations, the trial court didn't err because the defendant did receive the benefit of that specific provision, the minimum sentence of having cooperated of the 5 years, whether the reading was just the fact that he committed a new offense on release, or if he had committed a new offense before he finished cooperating in all of his matters. And so the trial court reached the correct result when it imposed that minimum sentence under paragraph 9E. It should be noted that the trial court, as mentioned in the people's brief, wasn't bound by paragraph 9E anyhow, Your Honors. It could have imposed the statutory maximum penalties under paragraph 12. That paragraph allowed the trial court to reject the provisions regarding sentencing, including paragraph 9, and impose sentence and paragraph 8 and 9, and impose sentences up to the statutory maximum contained in paragraph 2 of the global plea agreement, which again was 15 years imprisonment for the very very serious offenses that the defendant pled guilty to. Thank you, Your Honors. If there's nothing further, the people rest on a written brief.
I don't have any questions.
Thank you.
How much time is remaining? Okay, you have approximately 9 minutes.
I have three counterpoints to make after the people's arguments. First, whether or not Mr. Tedtaotao specifically objected. When we look at the transcripts itself, Your Honor, Mr. Tedtaotao himself actually discussed the mental incident regarding the dismissal and what he thought. That's the core issue at today's hearing. The court, again, talked about the provision for the past few sessions, and those were their words, not mine. For those reasons, we do believe the applicable standard should be de novo. The second point I would like to make, people did say that Mr. Tedtaotao did cooperate after the mental incident occurred or was dismissed. That is true, but he never cooperated after the new charge. And that's exactly what the paragraph asks for. If I could use this court's own words in Piolet, if the people wanted to subject Mr. Tedtaotao under the circumstances that we see today, they should have been more specific. Frankly put, the paragraph itself states that the defendant must at least be given the chance to cooperate. For the mental incident, we know that that has not occurred. As a final note, when we look at paragraph 12, yes, the trial court could have rejected the plea agreement. They never did. And I don't want to suggest for a second that Mr. Tedtaotao could have freely committed any crimes while he's on release. The people drafted this plea agreement. I invite this court to look at section number 20 on the final page, where it does give the people the opportunity to withdraw the plea agreement if the defendant commits a new crime. They didn't, and they keep relying on paragraph 9E. The circumstances don't fit it, and we do believe that the trial court erred.
Let me ask, the government points out that at the time the global plea was entered, which was August 2018, the Justin Mano manner had already been dismissed. And so obviously, you know, they're not going to put a provision in that agreement that might warrant cooperation for a case that's already been dismissed without the potential for re-indicting that case later. And so how do you address that argument?
Your Honor, I think we're stuck with two issues here. One, they drafted the plea agreement, specifically paragraph 9E, to require a cooperation or a decision by Mr. Tedtaotao to not cooperate at all. But inherently included in that paragraph is the people's ability to re-indict the case. At the end of the day, they never did. Mr. Tedtaotao never had the opportunity to cooperate, yet they want to subject him to additional punishment under the guise that he had retroactively cooperated in the matter. Under their own words in the plea agreement, that does not fit. If there are no further questions.
No further questions.
Thank you, Your Honor.
Thank you, counsel. Thank you, counsel. Both did an excellent job today. Court will take the matter under advisement and will issue a written opinion, and will now stand adjourned. Thank you.
Bye.